Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today's 27 January 2026, years after Jesus. It's a Tuesday. We're in Takings, Private Property, and the Power of Eminent Domain. We're going to do a fair use, transformative reading of this seminal Harvard University published book, published in 1985, over 40 years ago. We started this last year for the 40th anniversary celebration of Sir Richard's book. We're finishing a chapter today called Takings and Torts. We're going to go from pages 47 to 56 to the end of the chapter. And we'd like to thank Richard Epstein for writing this. We'd like to thank Harvard University Press for publishing it. Go to Harvard University Press's catalog, and if you can find something by Richard A. Epstein, buy it. If you can find something by another TRP guest, Philip Hamburger, buy it. Get it and throw some business their way, or get it used if you want. This copy I purchased and began reading in 2021. And private property, how the Constitution was designed to protect private property, is of paramount importance for our republic going forward. As you guys know, the U.S. Constitution sets up a protection for a Republican form of government in Article 4, as you recall. And so we're toward that end, toward the end of limited government. We are pushing forward. And we have a reading from Psalm 33 that will be after. Let's dedicate this time to the Lord. Thank you, Lord, for this time. Help us understand what Richard A. Epstein is saying here in his chapter, Takings and Torts. In his section, Takings Prima Facie. I'm going to pause, clear my throat here. I muted. No, I didn't pause. Thank you, Lord, for this book being published by Harvard University Press. Apparently, they didn't realize what they were doing in publishing this. They were giving one to their enemies, their political enemies. But this is in a section called Takings Prima Facie, Takings and Torts. And we appreciate, Lord, the wisdom that you have granted to Richard A. Epstein. Apparently, you've enlightened his mind and enabled him to see some good things in your created order here of the value of protecting private property. We ask that you would help us steward that and open our minds to understand and receive the wisdom here. Help us avoid any mistakes that may be there in the future. Help us to make the world a better place according to how it's designed to flourish. In Jesus' name, amen. Okay, here we go. The issue of proximate causation arises in all types of takings cases. I'm on page 47. Proximate causation is the subtitle of this section in subsection in Takings and Torts, chapter 4. It's chapter 4, right? Let me double check. Let me double check. I believe it's chapter 4. Yep, chapter 4. In ordinary conversion suits, the defendant is typically charged with taking the plaintiff's property with his own hands. But this paradigmatic case does not determine the outer limits of liability. If the defendant sets a trap into which an innocent plaintiff drops his own chattel, the defendant cannot keep the chattel on the ground that he obtained the property by trap instead of by force. Similarly, if a defendant falsely tells the plaintiff that he can leave his goods in defendant's care, but then refuses to return them, he has taken them. Do these things make sense to you? It makes sense to me. So far, it's common sense. This is common law. I'm going to clear my throat. It's cold out, as you can tell from my Pendleton sweater that I have on. One moment, I'm not pausing. I'm muting it. I'm going to take a drink of water. We're going to do the best we can to get this material into your noggin and into your soul. Yeah, let's keep going. Yeah, so similarly, if a defendant falsely tells the plaintiff that he can leave his goods in defendant's care, but then refuses to return them, he has taken them. What is Richard doing here? He's giving you examples in the common law where between two private parties, some taking has occurred without the use of force. Okay? And how that was handled. Why is he talking about this? He's talking about this because, again, remember for part 8, this is part 9. We're moving toward the goal of treating the government as a private party would be treated. Okay? No special privileges for the government. The government is not royalty. Okay? However, the limits of liability is the limit of liability is passed if the defendant says he will not return the goods if handed over to him. The case is a gift rather than a taking. So the truth or falsity of the spoken words sets the jurisdictional limits of the takings clause. Again, makes sense to me. The difference between a gift and a taking, of course. In all conversion cases, it is strictly necessary to take into account all actions besides those of the defendant that are needed to complete the transfer of possession from plaintiff to defendant. Yet the length of the journey does not change the relative rights between the parties so long as the intermediate steps in the transfer are induced only by the defendant's force or misrepresentation. We're on page 48 at the top. By the central premise of representative government, the same rules apply when the government stands in the shoes of a private defendant. Okay? Same rules to the government. The same extension of causal chains can work in cases of destruction as well, thereby injecting the thorny tort issue of proximate causation into the law of eminent domain. All theories of causation are bound to stumble on difficult cases at the margin. The possibility of marginal error does not, however, imply that an adequate theory of causation, even causation by the state, exhausts its power with the damage inflicted by the direct use of force. Although causation begins with trespass, no private system has ever been content to make trespass the entire law of tort. In both common and civil law, causation must embrace some instance of indirect harm or consequential damages. Consider the exact parallels to the conversion cases above. The defendant hurts the plaintiff not by striking him directly, but by setting a spring gun or trap that the plaintiff triggers. Or the defendant does not injure the plaintiff, but tells him there's a safe path out of the bottom of the canyon when there is not. The extension of the causal chain must be made. The Romans prohibited by statute the killing of slaves and certain animals. Yet, even when they were pushed by the inherent logic of the situation to create the analogous action, like the action on the case, to control parallel situations when the defendant furnished a cause of death, as by offering the plaintiff poison on the pretext that it was medicine. Cases under the equity of the statute are also cases under the equity of the Constitution. Indirect causation receives proper treatment in Eaton versus BC&M R&R, a New Hampshire eminent domain case decided shortly after and in the spirit of Pompelli. And what year was that? 1872. In Eaton, now remember, listen to how he describes these cases. Indirect causation receives proper treatment in Eaton. Okay, so he's saying he agrees with the reasoning and outcome in that 1872 case. It's a railroad case. In Eaton, the defendant railroad, acting under public authorization, made a large cut in the ridge of a hill, in consequence of which natural water intermittently flooded the plaintiff's land, reducing its fitness for cultivation. The close connection between the public law of eminent domain and the private law of tort was revealed in the first sentence of that opinion. So Richard's saying this is why this is a good setup. This is why it's receiving proper treatment. The close connection between the public law of eminent domain and the private law of tort was revealed in the first sentence. There's a close connection there. It is virtually conceded, this is a quotation, quote, it is virtually conceded that if the cut through the ridge had been made by a private landowner who had acquired no rights from the plaintiff or from the legislature, he would be liable for the damages sought to be recovered in this action, unquote. The court faithfully applied this premise to the proximate cause issue. We're on page 49 at the top. Again, we'd like to thank Richard Epstein for writing this. It's Richard A. Epstein. This is Takings, Private Property in the Power of Eminent Domain, published by Harvard University Press, 1985. We'd like to thank Harvard University Press for making this material available. We're going to do a fair use, do a transformative reading of this material. I would highly recommend that you get a physical copy of the book and follow along. Get a physical copy of the book and follow along. Get your own copy of the book and follow along. Get a pencil and make notes in the side and follow along. That's the only way you're going to learn is if you put some elbow grease into it. This is not pixie dust I'm sprinkling over your head. You have to do something to prepare the soil of your soul and your mind to receive this. Or you could remain ignorant. It's your call. It's your soul. It's your mind. Not getting rich over here. I'm doing this because I really believe in it. The court faithfully applied this premise to the proximate cause issue. It noted that it is wholly immaterial whether the plaintiff proceeds from a trespass theory or owing to the causal intervention of natural forces upon theory patterned upon the rule in Rylance versus Fletcher. That would be 1868. Judge Smith made all the right causal arguments. He rejected the argument that the water had come naturally upon the plaintiff's land, given that the defendant had to deal with the soil that had previously held the water in check. If, he noted, the ridge, this is a quotation from the judge in that case, if, quote, if, he noted, the ridge still remained in its natural condition, could the defendants pump up the floodwater into a spout on the top of the ridge and thence by means of the spout pour it directly on the plaintiff's land? If not, how can they maintain a canal through which the water by force of gravitation will inevitably find its way to the plaintiff's land? Unquote. That the harm involved is remedied under an action on the case and not under a writ of trespass has no bearing on the constitutional question, as there is no reason to believe that, quote, the framers of the Constitution meant to entangle their meaning in the mazes of the refined technical distinctions by which the common law system of actions is perplexed and encumbered, unquote. If the defendant had purchased the right from the plaintiff before the harm had taken place, he could be said to have acquired a, quote, flowage easement. And the result is scarcely better for the defendant because the flooding took place without the previous purchase of the limited right, unquote. In essence, the damage to the land was a partial taking of the land. Recall, he's talking about what he thinks was the proper treatment in Eaton versus BC&M Railroad and New Hampshire eminent domain case, 1872. That's what he's interacting with. In essence, the damage to the land was a partial taking of the land. For even though the plaintiff was left in possession, he was deprived of its ordinary use, one of the major incidents of ownership. We're on the bottom of page 49. It is, however, all too easy to lose sight of the basic principles of eminent domain and to return to the arid formalities exposed in Pumpelly and Eaton. In particular, it seems clear that the law relating to air easements and the like has not benefited in the slightest from the earlier analysis of the flooding cases. The seeds of confusion were planted in United States versus Cosby, and that would be 1946. Yeah, I remember that one. That has to do with the government planes causing problems in the air above land, causing damage. 1946. Okay, so yeah. Okay, so you got air issues and land issues. You got issues. There's some cases of air where the government causes problems in the air. Usually it's the military to the land. So the government, public, causes through military action, training and research and development and so on and so forth, problems to private landowners on land. Okay. And the first one, he's saying there's some problems here. The Supreme Court is causing problems because it's screwing something up here. The seeds of confusion were planted in United States versus Cosby, which is one of the air ones, the military ones, right after World War II. It's important to read between the lines sometimes on these cases. When you look at, that's why I always say the date of the case, because at 1946, you have to understand, 1 year before we were at war, there was an entire world war. Uh, so um, when the government, especially the military, is in court, maybe they're getting some deference here because there was just a freaking world war that we won. And the air control of the air was a major part of it. I mean, the control of the air ended the war, if you recall. We had control of the air over Japan. And eventually that led to control of the land in Japan, which ended the war. The seeds of confusion were planted in United States versus Cosby, 1946, where the court held that the government was obligated to compensate private landowners for the taking of in an in an overflight easement when military planes routinely entered the plaintiff's airspace in the course of landing and taking off. The entry itself was treated as an ordinary trespass and hence taking of airspace, for which the inconvenience and disturbance to the landowner was but one component of actionable damages. Listen to this. The unfortunate implication of the rationale is that the entrance into protected airspace, not the disturbance it generated, forms the gist of the government wrong. Okay, that's the problem right there. Why would that be a problem? Well, you're going to find out. This is why it's important to have the correct reasoning, not just the correct result. You want both the correct reasoning and the correct result. Because if you get, let's say you get the right result, but for the wrong reason, once the reasoning is corrected, it might lead to a different result other than the right result because you've already established the principle that the reasoning and the result don't have to be related to each other in any kind of epistemically normative way. Errors in principle, however, quite lead easily to errors in result. In Batten versus United States, and that would be 1962, 10th Circuit, the question was stated by the as stated by the court was whether a taking of property compensable under the Fifth Amendment occurs when there is no physical invasion of the physical occurs when there's no physical invasion of the affected property, but the operation and maintenance of military jet aircraft, as on an Air Force base of the United States, produce noise, vibration, and smoke which interfere with their use and enjoyment of property. The court answered the question in the negative, largely by insisting upon the exploded distinction between the taking of property on the one hand and the mere damage to property on the other. I'm actually going to read that footnote. It's footnote 45. The case tends to belie the assertion that the omission of the quote or damaged language has had no effect on the adjudication under the eminent domain clause. See Bruce A. Ackerman, Private Property and the Constitution. You know, I did a paper on Bruce Ackerman in graduate school back in 2010. I'm going to have to dust off my notes and, I'll make a little note of that to get back into Bruce Ackerman. See what he says about that. I'm interested. Okay, that was footnote 45. The court denied recovery with the announcement that, quote, the record shows nothing more than interference with the use and enjoyment, unquote. Do you know Richard Epstein enough to know now how he's going to interact with that? Yet, here's Richard. Yet that is precisely the reason why compensation should be awarded. Why did I not have that underlined? And you have it's like the denouement in a horror film here. One of the least defensible of all 19th century tort distinctions was that between damage by blasting, governed by a strict liability rule, and damage by vibration and the like, governed by a negligence rule. The court in Batten, and that would be the 10th Circuit case I just mentioned from 1962, the court in Batten, the Air Force case, vibration case, noise, smoke, use of enjoyment. The court in Batten has taken this distinction one better at a constitutional level. For in its own view, the classification of the nature and source of the harm now goes not merely to the question whether negligence must be alleged and proved, but to the much larger question of whether any recovery will be granted at all. Let me just note here, and this is me, okay? I think what Richard is doing here is he's uncovering a tendency of the courts to make mistakes that sometimes bias in favor of the government. And the mistakes could be mistakes in reasoning or just making crap up that doesn't make any sense. Um, to be sure, this is page 50 at the bottom. Do I need to read footnote 47? I think I need to read footnote 47 to you. Hold on. The key 19th century cases are Hay versus Cohoes, New York, 1848, authorizing strict liability actions for blasting damages, and Booth versus Rome, also New York, 1893. The distinction was laid to rest in Spano versus Perini Corp. That's also a New York one, Second Circuit. Hold up. No, sorry. Yeah, it's a New York case, 1969, which authorized strict liability actions for both blasting and vibration damages. The doctrinal situation, however, has not come to rest in New York because Copart Industries versus Consolidated Edison Company, and that would be 1977, points toward adoption of a negligence standard in nuisance cases that are distinguished only with difficulty from the ultra hazardous cases. We are not talking about, I don't think we're talking about nuisance here. We're talking about ultra hazardous. I think these Air Force cases are ultra hazardous. I'm not totally sure about that, but if that footnote was not helpful for you, don't worry about it. If that's why I say have the book and follow along because it's really helpful to just be able to make your own notes here. Okay, to be sure, Batten does not allow, oh, sorry, Batten does allow, that's that 10th Circuit case, 1962, Air Force case. Batten does allow for some play in the joints by noting that compensation is required for some cases, as in Richard versus Washington Terminal uh, Company. That would be 1913. It's going to be discussed in more detail later, where recovery was allowed because smoke and fumes were driven out of a tunnel by exhaust fan and directed across the plaintiff's property. Richard, page 51 at the top, Richard, that's the name of the case, Richard versus Washington Terminal Company, 1913. Richard is far more important than this grudging concession to principle might suggest because it indicates in the way foreshadowed by Pompelli how the integrity of the eminent domain clause is preserved only if takings include damage and destruction. That's a very good quote right there. Just going to note here. I have a check mark, but I'm going to go a step further and put brackets around that. Yeah. So Epstein is saying over and over again, a taking occurs by a wide variety of types of actions here, not just what the government wants to concede as a taking, but there's a full display which includes damage, includes uh, an impairment of use, and the um, interference of use and enjoyment of a property would count as a taking. Okay. Now, I'm going to read that sentence again then. Okay. To be sure, Batten does allow for some play in the joints by noting that compensation is required for some cases, as in Richard versus Washington Terminal Company, 1913, where recovery was allowed because smoke and fumes were driven out of a tunnel by an exhaust fan and directed across plaintiff's property. Richard, the 1913 case, that's a Supreme Court case, is far more important than this grudging concession to principle might suggest, because it indicates, in the way foreshadowed by Pompelli, how the integrity of the eminent domain clause is preserved only if takings include damage and destruction. The concession only reinforces the central point, for Richard requires that all nuisances be treated as physical invasions and therefore as takings prima facie, compensated under the eminent domain clause. To insist the court does in as the to insist the court does in Batten, to insist the court does in Batten that ordinary nuisances are not physical invasions is to act not only against sound theory, so he's criticizing the 10th Circuit here in that 1962 case. To insist, I think he means as the court does in Batten. I think there might be a missing prepositional preposition there, as. To insist, the court does. I think it's as. I think I just found a mistake in Harvard University Press. To insist, it should be as the court does in Batten, that ordinary nuisances are not physical invasions is to act not only against sound theory, but also against the uniform judgment, both ancient and modern, on the status of ordinary nuisances. That's a pretty that's a pretty hefty criticism of the 10th Circuit there. It cannot be that the tort of nuisance is foreign to the eminent domain clause, that is on its face designed to protect private property. Richard has a way of bracing you. Just it's like a flash of cold water on your face. Just bam. There has all there has been a welcome retreat from the Batten position in the case law, and some recognition at the legislative level that it produces inexcusable, indeed outrageous results. Okay, what does he say here? Footnote 50. We're skipping that. It is all too tempting to regard any retreat from the no compensation position as a matter of legislative grace. Oh, wow. It is all too tempting to regard any retreat from the no compensation position as a matter of legislative grace and not of constitutional command. He's saying that that's a mistake. It's not legislative grace to admit there's compensation owed here for these kinds of abuses. It's constitutional command. That's a fair summary of this book right here. And the courts have a special role. The legislatures do too. But, if the legislatures infer that this is, the plaintiffs are coming, your grace, I beg your mercy, your grace, for some compensation. It's not legislative grace, it's constitutional command here. Yeah, that's great. It is all too tempting to regard any retreat from the no compensation position as a matter of legislative grace and not of constitutional command, as if nuisances raised matters of fairness that somehow fall outside the scope of the eminent domain clause, which is in the U.S. Constitution. What is needed, however, is not an erratic and unprincipled temporarization. Well, I screwed that up. Sorry. I screwed a word up. What is needed, however, is not an erratic and unprincipled temporizing, but the complete repudiation of Batten, that 1962 10th Circuit case, Air Force case, and the philosophy it incorporates. as a matter of both common law and of constitutional doctrine, full compensation is prima facie required. We're on the bottom, page 51. How are you guys doing? Consequential damages. In both public and private cases, the problem of causation extends to the issue of consequential damages. What losses stemming from the original wrong should also be compensated? Situations that present this problem are common in that both the taking and the destruction of private property may result in a plaintiff losing profits and business goodwill, page 52 at the top, and incurring the expense of relocation and attorney's fees. The most extreme case is the condemnation of a large tract of land, which destroys not only many small businesses and homes, but also the sense of community. Detroit's use of the eminent domain power to condemn the Poletown neighborhood to make way for a General Motors plant is but one illustration of the problem. I am checking these footnotes just to see if there's anything interesting or useful. I'm skipping most of the footnotes. And by the way, good job, Richard, for including footnotes and not merely endnotes. Nice job. Yeah, to compensate for the loss of land values without regard for the associational deprivations is again to use tests of remoteness of damage that are utterly inappropriate for private defendants and, by implication, for the government as well. Here again, he's treating the government like a private, like the same standard. The government doesn't get a pass. There's no, grace, there's no royalty here. It's just the government. Nonetheless, the courts uniformly deny all such claims on the textual ground that the government has gone into possession of the land alone, but has not taken the additional items of loss. See, there's a pro-government bias there. The emphasis is thus upon the values that have been transferred to the government and not those that are lost to the owner when the government is unable to use them in its own business. Quote, if the business was destroyed, the destruction was an unintended incident of the taking of the land, unquote. While the general rule remains that quote, the question is what the owner lost, not what the taker gained, unquote. Consequential damages of all sorts have been excluded from its purview on the ground that the government need only pay for that which it gets. That's a government bias because that standard does not apply to private parties. Okay, I'm gonna take a drink of water and let you think about that for a sec. I'm muting it. I'm enjoying this. I hope you are. Yet the exclusion of consequential damages from the plaintiff's losses in eminent domain cases cannot be defended. Tell us what you really think, Richard. Let me check out this footnote 53. Mitchell versus United States, 1925. See also Kimball Laundry Company versus United States, 1949. At issue in the case was whether the government, which had made a temporary taking of appellant's laundry, was required to compensate for the loss of its route values, which were of great value to the company, but of no value to the government. The court allowed compensation for the transferable value of their temporary use may have had. the transferable value their temporary use may have had. The dissent relying upon Mitchell, that's a 1925 case, would have denied recovery completely. Wow. Whew, that's scary. I got to check who was on that side. I got to check that. The majority's grudging concession is far too restrictive, as he's talking about Kimball Laundrie, 1949. The majority in that case is grudging concession is far too restrictive, as the transferable value of the rights may have been far less than their value and use. Hmm. Yeah, the proper measure of the loss is the present value of the income stream during the period of occupation, plus any loss in the value of the route system upon termination. Yeah, that sounds right to me. I think, I really think that Richard is on to something in this entire book. Mitchell versus United States, 1925. Relying on Mitchell would have denied. Okay, so I got to check out Kimball Laundrie. Looks like it was mostly Democrats on that. It might have been entirely Democrats on the Supreme Court by that time. I want to see who was on the dissent. I'm going to look that up. I'm going to pause this and look it up. Okay. I looked it up on Google Scholar and just poked around in it. Um, the I think it's all Democrats on the Supreme Court at this time. Remember, this was 1949, so this would have been after one Democrat in particular was reelected 3 times. Remember, four successful elections of the Democrat Franklin Delano Roosevelt. And then, his vice president, Harry Truman, served the rest of his term during World War II at the end, and then won an election in 1948. So you have all these guys are Democrats. This guy right here, Justice Black, was a member of the Ku Klux Klan, ironically, that last name Black. Chief Justice was Vinson, who was this man. Let's put it this way. If Vinson was on the court during Brown versus Board, Brown versus Board would not have been unanimous, I don't think. Anyway, um, yeah, so this is very interesting. It's worth poking around in. I'm not going to spend too much time on it, but it's a little scary that Democrats had a stranglehold on the Supreme Court at that time. I mean, it's at least scary to me. Maybe it's not scary to you. Maybe you guys don't give a crap, you know, but I do. Who was Harold Burton? Gosh, looks like he might have been a, yeah. Well, anyway, let's keep going, okay? Richard, thank you for writing this. This is so good. This is so good. Oh man. Okay, what was the last thing we'll reread that sentence, last one. While the general rule remained that the question is what has the owner lost, not what the taker gained, has the taker gained. Consequential damages of all sorts have been excluded from its purview on the ground that the government need only pay for that which it gets. That's a mistake. Yet, the exclusion of consequential damages from the plaintiff's losses in eminent domain cases cannot be defended. The eminent domain clause, like all provisions in the Constitution, is not designed to protect the thing owned. It is designed to protect the owner of the thing. That is awesome. I have a quotation sign in the margin there. The eminent domain clause, like all provisions in the Constitution, is not designed to protect the thing owned. It is designed to protect the owner of the thing. Can I just rail in a Second Amendment context really quick on people who use the term gun rights? I never use that term. Gun rights. Guns don't have rights, guys. Okay? People have rights. People have a right to keep and bear arms for self-defense and other lawful uses. That right shall not be infringed. It's the people that have rights. It's not politically successful when you use these terms. It's confusing. People, you want to avoid confusion. You got to have clarity in language. Okay. People don't feel sorry for guns. They feel sorry for the individuals who are criminalized for exercising or engaging in innocent conduct. It's people that suffer. Okay. Just think about that. If therefore it is the loss to the owner which functions as the proper measure of compensation, then all consequential losses attributed to the admitted taking, including destruction, are recoverable, just as they are routinely recoverable against a private defendant. Page 53 at the top. If the destruction of property itself is a taking under the eminent domain clause, then the infliction of consequential losses is a partial taking that the clause also reaches. As a matter of justice, the individual plaintiff is not made whole when these consequential losses are systematically ignored. As a matter of general social welfare, the rule invites the government to embark on programs where the expected losses exceed the probable social gains, making all persons net losers in the long run. Let's take a look at page footnotes 56 here. I'm going to take a look at footnote 55 here too. Hmm. I'm gonna go ahead and pause it. Okay, I skipped right over footnote 55 and I meant to actually include it. Footnote 55 ends on the following sentence. The eminent domain clause, like all provisions in the Constitution, is not designed to protect the thing owned. It is designed to protect the owner of the thing. Okay, so this point dates from Blackstone commentaries. Quote, in this and similar cases, the legislature alone, and indeed frequently does, interpose and compel the individual to acquiesce. But how does it interpose and compel? Not by absolutely stripping the subject of his property in an arbitrary manner, but by giving him a full indemnification and equivalent for the injury thereby sustained. The public is now considered as an individual, treating with an individual for an exchange. All the legislature does, says Blackstone in his commentaries, all the legislature does is to oblige the owner to alienate his possessions for a reasonable price. And even this is an exertion of power which the legislature indulges with caution and which nothing but the legislature can perform. Now, that's in a system of legislative supremacy, the British system. Note, that's the end of the quotation from Blackstone, still on footnote 55, bottom page 53 now. Note that the indemnification and equivalent for the injury thereby sustained should cover consequential damages. Okay. Fair enough. Using Blackstone here. Okay, good. A little bit of background on Richard. He studied at, I think he studied at Oxford before he went to law school. He studied law over there. So he got an education in the common law versus the civil law in England. I think he studied Roman law quite a bit too, which is what the civil law is based on. The distinction between common law and civil law is really a distinction between the British system and like French Catholic type systems, all the Catholic countries, Italy, based on Rome. Okay, you have that. You have it. The British went different. The British had a Reformation that. Well, anyway, I don't want to get into that. Why are you getting me into that? Just file it away. Just file it away. Now, here's a natural law point he makes on page 53. The injustice, for such it is, of the current rule is widely recognized in the decided cases and academic literature. Footnote 57. Chapters 17 through 19. Well, he's going to develop that further later on. I can't wait. But this broad academic consensus on the basic point has not been matched by a judicial willingness to overturn established doctrine. See, this is his criticism of the judicial branch. They're not exercising the judgment like they should be. They're not exercising the judicial power. They should be more active and more reasonable. Their rationale isn't tightened up. It's not in sync with with the Constitution. It's got to enforce the Constitution here against the government. Why would they do that? They are the government. Well, yeah. I mean, is this the best? Is this as good as it gets? A party cannot be a judge in its own case, but when you zoom out and you notice that the courts are part of the government, that's exactly what's happening. The government is party to a case, and the government is also a judge in its own at that level of generality. That's true. Let's keep going. One recent case that illustrates the extent to which modern progressive courts are prepared to indulge in sterile analysis to suppress their own sense of justice is Community Redevelopment Agency of Los Angeles versus Abrams. Oh, an LA case. Jeez, 1975. There, the plaintiff was an elderly pharmacist whose place of business was condemned by the redevelopment agency as part of a comprehensive plan for urban renewal. The agency paid for the land, but balked at compensating Abrams for two additional heads of damage, loss of business goodwill, and destruction of his stock of ethical or prescription drugs. The loss of business goodwill could be attributed to the condemnation because the urban renewal program had dispersed Abrams' former clientele, and his old age and questionable health made it difficult, if not impossible, for him to begin his business again in a new location. Page 54 at the top. The ethical drugs were destroyed because an applicable California health regulation required that all such drugs, once removed from their sealed containers, be opened and inspected by state authorities before being resold to another pharmacist, a procedure that in this case cost more than the market value of the drugs itself or themselves. This pharmacist was screwed by the government. That's what Richard is saying. The court denied both heads of compensation, even though no private defendant could escape payment if he forcibly ejected an owner from his place of business. What he's saying there is the government was treated like a little princess who can just do whatever she wants to do, not like an ordinary private party. And that's bad. That's not what the system was designed to do in the Constitution. The case for compensation by the state, moreover, becomes perfectly clear in light of the specious tort analogies invoked by the California Supreme Court. Now he's criticizing the California Supreme Court. He's just called the tort, he called their tort analogies specious, which is derogatory. Okay. Surely no defendant's jurisdiction in tort Surely no defendant's jurisdiction in tort cases to deny recovery. Let me read that whole thing again. The case for compensation by the state, moreover, becomes perfectly clear in light of the specious tort analogies invoked by the California Supreme Court. Surely no defendant's jurisdiction in tort cases to deny recovery. At one point, the court attributed the plaintiff's loss to his own weakened condition. That's abuse right there. The argument fails as a factual matter, for the dispersal of the plaintiff's clientele could not have been prevented even by a plaintiff in full vigor of his youth. Nor does it matter that the younger owners might have further mitigated the losses. In California, as everywhere else, the tortfeasor, that's the one that does the tort, commits the tort, the harm. The tortfeasor takes his victim as he finds him, be it for his thin skull or for his old age. The government stands in no better position. That's his theme, his constant theme. The government is not a little princess that can do whatever she wants to do and just kind of, and you have to bow down and call her royalty and please the crown. I mean, this little bitch princess is saying it's your fault, old man. You were old for what we did to you. That's how crazy these progressives are. By the way, he uses the quotations around progressives. I should have said that. He says, um, he says, our recent case that illustrates the extent to which modern, quote, progressive, unquote, courts are prepared to indulge in sterile analysis to suppress their own sense of justice is Community Redevelopment Agency of Los Angeles versus Abrams. It's that pharmacist case. Page 54. The denial of the claim for loss of the ethical drugs fares little better. The plaintiff destroyed those drugs under compulsion of state action. Between the party that destroys under the threats of another and the party that makes the threat, the loss should properly lie upon the threatener, even though he is more distant in both time and space from the harm. He forced me to harm myself. This is footnote 61, and he's quoting himself. Okay. The position is not controversial in any system that understands duress. Overly restrictive theories of causation, universally rejected in tort contexts, should not be called in to aid the government in eminent domain cases. Goodwill and consequential damages are part of the covered losses, and prima facie are compensable as such. The question of consequential damages also arises with the expert appraisal and litigation fees individual property owners incur during the course of condemnation, page 55 at the top. Again, we're interacting with Richard A. Epstein. Takings, Private Property and the Power of Eminent Domain, Harvard University Press, 1985. 40 years ago, we started this series. We're on part 9. This is part 9 of a series celebrating the 40th anniversary of this publication of this book. Now it's 41 years. If you just go by the year, I don't know what month it was published. And we'd like to thank Richard Epstein for writing this. We'd like to thank Harvard University Press for making it available. Go out to Harvard University Press's catalog, find books written by Richard A. Epstein and or Philip A. Hamburger. I'm going to throw his name in there because they're both I'm fans of both. Hamburger is a professor at Columbia in New York City, Columbia Law School. He came on the podcast. Great, great time with him. I really highly recommend anything he writes and that episode that we did. Let's keep going here. The received legal doctrine on this point follows from the central proposition of Justice Brewer and Mano Gahalia. I don't know how to say that word. Sorry, I'm going to try it again. Manan Gahel. And that's 1893. Monongahela Navigation Company versus United States, 1893. That compensation is tendered only for the property taken and not for the losses sustained by the owner. As the government does not keep the litigation and appraisal fees spent by the private party, it follows under the orthodox analysis that the government is not required to compensate for their loss. Let me look at this footnote here really quick. Okay. One justification of this result rests upon the observation that the private owner normally has to bear all these costs when land is sold in the voluntary market, so the net recovery is the price paid less the expenses of sale. Nonetheless, the analogy is wholly inappropriate. Yes, very good. Given that the sale to the government under its eminent domain power is involuntary. So, in other words, any fees, like attorney's fees and stuff like that, also are losses compensable. And there's always going to be this temptation, it seems like in that Monongahela case, 1893, that where you're just making excuses for the government, the little princess, you know, she doesn't have to pay your attorney's fees. Well, that's not true. It's under the eminent domain clause, that would not be how it's designed. The analogy is wholly inappropriate because the sale is involuntary. In the voluntary market, the simple fact that the seller has entered into the transaction is evidence that he regards the net price as a fair equivalent for the property surrendered. No such inference can be drawn where the sale is involuntary, for it is clear that the owner prefers the stream of income derived from the use of property to the net condemnation proceeds. In short, it follows that the owner is not indifferent between the property lost and the compensation tendered, as the basic theory of the takings clause requires. Very good. This is very good. Page 56, and we're almost done. The only real question, therefore, is to determine how to take into account these additional expenses. There is an obvious risk in compensating the individual owner for whatever expenses are incurred in valuing the property or in resisting the takeover, for the private owner will be tempted to spend lavishly if the government must pick up the bill. One possible solution is to scrutinize the expenses for reasonableness on a case-by-case basis, so that efforts to resist a takeover on the ground that it is not for public use will be disallowed if the land is taken for a highway. The case-by-case method has the advantage of capturing the variation in costs associated with different types of properties. Yet, it has the corresponding disadvantage of increasing the administrative costs for the system and of allowing the introduction of error. It might be preferable to develop administratively routine formulas to increase the awards paid for different classes of property to take into account these costs. This might also allow individual owners to prove additional expenses so long as they are prepared to compensate the government if their own claims are judged inflated or unreasonable. There can be serious disagreement about how the details of any such compensation system will work, but the range of options is sufficiently well defined that no matter which is chosen, the outcome will be more consistent with the constitutional text than the current rules routinely denying such compensation. I agree with that. I'm going to make a note. This is TRP episode on 27 January 2026 years AD. It's a Tuesday. And this is part 8. No, sorry, part 9. Part 9, honoring Richard Epstein's um, work here, 47 to 56. The next chapter is partial takings, the unity of ownership, and we continue. And it's good stuff. Again, the book is Takings, Private Property and the Power of Eminent Domain by Richard A. Epstein, published by Harvard University Press. And I highly recommend you go out and get a copy of it. Follow along. We have a reading from Psalm 33. Sing for joy in the Lord, O you righteous ones. Praise is becoming to the upright. Give thanks to the Lord with lyre. Sing praises to him with a harp of 10 strings. Sing to him a new song. Play skillfully with a shout of joy, for the word of the Lord is upright, and all his work is done in faithfulness. He loves righteousness and justice. The earth is full of the loving kindness of the Lord. Verse 6, Psalm 33, and this is the New American Standard Version. By the word of the Lord by the word of the Lord the heavens were made, and by the breath of his mouth all their hosts. He gathers the waters of the sea together as a heap. He lays up the deeps in storehouses. Let all the earth fear the Lord. Let all the inhabitants of the world stand in awe of him. Verse 9, for he spoke and it was done. He commanded and it stood fast. The Lord nullifies the counsel of the nations. He frustrates the plans of the peoples. The counsel of the Lord stands forever, the plans of his heart from generation to generation. Verse 12, Psalm 33, NASB. Blessed is the nation whose God is the Lord, the people whom he has chosen for his own inheritance. That's a very famous quote, by the way. Blessed is the nation whose God is the Lord, the people whom he has chosen for his own inheritance. The Lord looks from heaven. He sees all the sons of men. From his dwelling place he looks out on all the inhabitants of the earth. He who fashions the hearts of them all, he who understands all their works. The king is not saved by a mighty army. A warrior is not delivered by great strength. A horse is a false hope for victory, nor does it deliver anyone by its great strength. We have a few more verses here, but I want to point out Deuteronomy 17. Take a look at Deuteronomy 17. Deuteronomy 17. Look what it says about horses. By the way, notice that Jesus could have come into Jerusalem in the final week of his life, which we celebrate with Palm Sunday. It's written about in, for example, the Gospel of Matthew, riding on a mule, a colt, a mule, okay, a donkey, a mule, not a horse. He was not on a horse. Verse 18, behold, the eye of the Lord is on those who fear him, on those who hope for his loving kindness, to deliver their soul from death, to keep them alive in famine. Our soul waits for the Lord. He is our help and our shield. For our heart rejoices in him because we trust in his holy name. Let your loving kindness, O Lord, be upon us, according as we have hoped in you. Psalm 33, New American Standard Version. A moment of reflection. Thanks for joining me on The Republican Professor. I've been your host, Dr. Lucas J. Mather. It's Tuesday, 27 January 2000, 26 years after Jesus. We've been interacting with takings, private property, and the power of the eminent domain. We just finished part 9 of the 40th anniversary of this book, published by Harvard University Press, 1985. And we're going to keep going through, hopefully, to the whole thing. We've also had a reading of Psalm 33 in the New American Standard Bible version. And God bless. We're going to keep plugging through these topics. I've enjoyed this time with you. I hope you have too. Is it challenging material? Yes. That's probably my fourth time reading that. Maybe probably not the fifth time, like the fourth time. And I do have to check the cases. I do have to do research in addition on the footnotes. I have to familiarize myself with what he's talking about. And that's normal. That's just part of what it is. And there's no shortcuts. AI will not shortcut anything for you. There's nothing you can do to shortcut this. If you put in the work, you can reap rewards for yourself and your community. God bless you. We'll see you next time.